Okay, everyone, we're back. This is Advocacy Alchemy with Professor Ross, and we're going to view a video. We're going to view this one. Judge loses patience with a repeat offender and tells him hands down 40 years
Sentencing in
max.
3 files, 22-6457, 23-6764, and 23-6765. Counsel, you want to state your appearances, please?
Melissa Goodrich, Boone County Prosecutor.
Jeremiah Buffalo, we're on behalf of Mr. Sayers, who is seated to my right.
Okay, and have you had a chance to review the probation violation report?
Yes, Your Honor, we reviewed it some time ago. The court had been setting these matters out due to Mr. Sayers' other pending matters that are presently here in Sheboygan. We would ask that the court continue to hold that out so we can handle those other matters.
And my only problem with that is now it's alleged that he's committing crimes while he's in our jail, so I'd like to get him out of our jail. So I'm going to proceed with sentencing today.
Okay. Now, I have not seen this one already, but let's talk about what's going on here. All right. So you have a person that is currently in jail and they're having some issues while the person is in jail. So the judge just made mention that they need to go ahead and get him out of the jail and into the Department of Correction. Now, this one starts off, let's actually look and see where this is from. All right, this is Judge Gauthier. He is where? All right, information about the channel itself. This is from Gavel Gazers Court Watch. That's the name of this group who have obtained this footage. Let's see, I don't see where or what state we are talking about, but we can find him. Let me see if I can find him really fast. Judge Gauthier. Aaron Gauthier. All right, he's the Chief Judge of the 53rd Circuit Court of Michigan. So this is in Michigan where we're talking about. So with that, I know to pull up Michigan law. Let's go with Michigan criminal law. Michigan criminal law. I have it pulled up in another tab and we could just switch to that tab. All right, so we have the Michigan Penal Code is what we'll be talking about here in just a second. Let's come back over this tab and let's start.
It's noticed for sentencing today. Any additions or corrections to report?
No, Your Honor.
Ms. Goodrich, any additions or corrections to report?
No, Your Honor.
Or anything you want to say on Mr. Sayers' behalf?
Yes, Your Honor. Mr. Sayers is a victim of addiction, Your Honor, and addiction rears its head in many ways, and it has got a hold of Mr. Sayers, Your Honor.
Okay, so let's stop this for a second. Let me explain. So what's going on is that he is currently subject to this is a sentencing hearing. So at a sentencing hearing, that's when a defendant is brought in and the sentence that's going to be imposed is announced. Now, this usually happens, it can happen several different times, okay? So one way is a sentencing hearing can be had after a jury trial that's been broken up into different phases, all right? Here where I practice, jury trials happen in 2 phases. You have the guilt or innocence phase and you have the punishment phase, okay? So the jury goes back twice. We usually try to do it all in the same trial. That way you can keep up with your jurors and you don't lose people in the meantime due to time limitations and things of that nature. Now, here you have a sentencing hearing that's probably as a result of a plea bargain, a plea that was reached between the prosecution and the defense team. All right. Now, when that happens, sometimes a plea will be taken on one day, meaning they signed all the paperwork and the person announced to the judge that they wish to take a plea, and they tell the judge, they go through certain yes and no's to determine whether the person is freely and voluntarily entering into a plea agreement. All right, because once a person enters into the plea, the only thing left is sentencing, and a person will then have to face the punishments that they accepted during the plea. All right. So here they probably set sentencing out further than when the plea was taken. So a person has to then come back to court and find out what the range of punishment they're going to receive is. Or I guess not necessarily the range, but what the punishment is going to be that they're going to have to serve. All right, so let's get back into it. Let's see what Judge Gauthier has to say.
I believe that the best possible solution for Mr. Sayers is to be engaged in treatment, and we would
I
ask.
think so too. And so I sent him to treatment and he walked off and absconded. So I don't know how to get him to treatment. I agree 100% with you. The problem that we have is that Mr. Sayers doesn't agree with you or me.
In my conversations with Mr. Sayers, Your Honor, he does. He acknowledges that these acts that are alleged are tied to an addiction, and he needs the help. So, Your Honor, we would ask that the court fashion a remedy that allows for rehabilitation as opposed to punishment.
Thank you, Mr. Sayers. It's not required.
Now, in criminal court, this happens quite often. People will, when I say people, defense attorneys during sentencing or when we get to that phase when we're talking about punishment and what the punishment is going to be. Here, that can happen during a revocation hearing. At the end of a revocation hearing, both sides will have an opportunity to tell the judge what they believe should be the sentence, what their recommendation is. Now, when there's a jury, both sides argue to the jury on what they believe the sentence should be. All right. But it's up to the jury to make a decision on what the sentence is going to be. It comes back to the judge. And as long as it's in compliance, and compliance is basically as long as they follow the jury instructions and they follow the verdict form instructions, because many times there will be a range of punishment. And as long as they don't punish outside of the range, then the verdict should be accepted as it is.
Sorry to say anything today, but it is allowed. Is there anything you want to tell me?
I'd just like to say that what he said is 100% accurate. I do struggle with addiction. I definitely need help. I want the help. I mean, obviously I've struggled with trying to get there, trying to do it myself. But I have two kids that definitely need me, family that needs me. I'm disappointed in myself for everything that I've done. I want to do better.
All right, notice they put commentary as just subtitles here. They had a cross here that says, it said, judge's face. Yikes. If you're ever involved in a bunch of criminal court, if any of you all ever determined that you want to become lawyers and you're dealing with criminal cases on a daily basis, you'll get a feel for the judge that you're in front of and how they are probably about to rule based on their expressions. Some people show it in their face. Some people are very guarded with what they are about to do.
Yes, that's all, Your Honor.
Ms. Figgett's recommendations from the people.
Yes, Your Honor, the defendant is 26 years old. He had 2 prior felonies and 6 prior misdemeanors before these cases. He was given a second chance by entering to recovery court, despite numerous warnings about taking it seriously and being ready for the program. Mr. Sayers has repeatedly said one thing and done another. He had made little to no effort during his time in recovery court, actually incurred another case upon release from jail to start recovery court. And now I received a warrant request today for conduct while in jail, waiting the sentence and having the other felony court case pending. So I'd ask the court to follow the recommendations. Thank you.
Thank you, Mr. Sayers. Please stand for the court sentence. All right, so we're here for sentencing on probation violation. In file 6457, you were on probation for resisting obstructing police by fleeing on foot from the police during a traffic stop. It's maximum 2 years. File 6765.
All right, we heard fleeing from police while at a traffic stop. Let's put that in. Michigan criminal law. Fleeing from a traffic stop. Let's see what it pulls back. All right, fleeing and eluding penalties. In Michigan, fleeing from a traffic stop is a serious offense under Michigan Penal Code Section 750.479A. Here are the key points. Fleeing and eluding occurs when a driver fails to stop for the police or conservation officer after being signaled to do so by hand, voice, emergency light, or siren. All right, so if you fail to stop after any one of those signals, then you could be subject to this crime and punishment in Michigan. Number 2, degrees of fleeing and eluding. 4th degree, the least severe, involves actions like increasing speed or turning off headlights to avoid police. It's a felony with up to 2 years in prison and a fine of up to $2,000. I think we just heard about this one, the 2 years in prison. So 3rd degree, more severe, involving a collision, accident, or prior convictions. All right, so if you got prior convictions, it enhances the penalty, and it enhances the level of crime. All right, it's a felony with up to 5 years in prison, a fine of up to $5,000. 2nd degree involves a serious injury or multiple priors. It's a felony of up to 10 years in prison, a fine of up to $10,000. 1st degree, the most severe, involving the death of another person. It's a felony up to 15 years in prison, fine of up to $15,000. All right, we have a recitation once again of the punishments, and I've been talking and talking, but I have not shown you. Here, I'll pause it here so you can take a chance and read. Pause the video here so you can take a look and see what I'm talking about. And once again, we'll talk about how I'm researching this. I pull back from here, but I'm going to open another one up and show you I can get the same information from Google too. All right, we talked about this before, but this is just a search engine. And I put in, this is my search, Michigan criminal law, fleeing from a traffic stop. I'm going to put the same thing into a Google. Let me go google.com. All right, we're over here. I'm going to put in the same information. Michigan law, fleeing from a traffic stop. It's already in here at the top. I'm going to select that and we're going to see what it pulls back. Let me take off some of these others so you can see what's going to pull back. All right. All right, as you can see, it's pulling back some stuff from Gemini also. I don't want anything from Gemini right now, but this pulled back directly from Google. So if you don't have any sort of other extensions available, it will pull back this information here that's been highlighted, okay? 750.479A, failure to obey direction of police officer or conservation officer to stop motor vehicle or vessel. Violation of subsection 1. fleeing and eluding as felony. Penalty, suspension of license, revocation, conviction, sentence under other provisions. This is the place where we would go to find it. It's taking us directly to the Michigan law. Michigan codified the MCL. I don't know what MCL stands for, but I'm sure it's something to do with the Michigan legal code. All right, this is exactly where it's found, 750 Act 328 of 1931. All right, this is where we will find that. So that's with a Google search. It allows us to find the same information, okay? You just have to do a little bit more work and it pulls back multiple results. But when you're trying to research, it doesn't matter if you have multiple sources. What's important is that you have the ability to go back and check on those sources and making sure that you go back over and read what's actually to be found there. If this didn't pull back this highlight here, okay, we could always go and find this same information, all right, and a page where it wasn't highlighted and picked out for us by simply pushing Control F if you're on a Windows computer, Command F otherwise, all right. And you can't see the top of my screen here because it only shows you a portion of it, but it pulled down a search bar to search for certain words. And I could search this whole document for failure to obey. It tells me it happens 1 of 1, and it's going to take me right there to right here in this portion. Okay, but this is the law. You read this part down here, it tells you the history of the law. All right, when was it added? All right, it was effective on March 10th of 67. It was amended in 1988, effective March 30th of 89. Let's see. There was another amendment in 96, effective in 97, 1998, effective in 99, amendment in 2002, effective July 2002. All right. And then another amendment in 2012 and effective November 1st, 2012. Okay. All right. That's how you read these. Don't be afraid to look up anything that you don't understand. Okay. The word you understand, look it up. If there is a code, if there's code language like this that you don't understand, highlight it, select it, copy it, and look it up and see what it says and see what you pull back when you're looking for that. Let's see. We'll put that in here and see what it pulls back. All right. Tells us the Michigan Vehicle Code about this and outlining certain things. Same information will pull back if we put that directly into Google, Yahoo, Bing. Any of those search engines will pull back this information. Okay. So it's important to know how to do legal research and how to do advanced research in general. Okay. That's all a part of the initial level, the high level, the big level overview of how to do legal research. All right, let's go back over here to the judge and let's see what he has to say.
Probation for fleeing and eluding 3rd degree, habitual 2nd, 7.5-year maximum. In that case, he fled in a car during a traffic stop, striking a police vehicle. Both high-risk behaviors.
See, high-risk behavior is you struck a vehicle, so it's not going to be on that low end anymore. Will not be at that 2-year level. It has to go up at least 1 or 2 levels. If he hit a police car, he's probably going to talk about whether the police were in the car or not. That's all considered very dangerous behaviors. And that's an additional charge usually.
You're on probation for delivery of methamphetamine, drug double, maximum 40 years. Possession with intent to deliver methamphetamine, drug double, maximum 40 years. Possession with intent to deliver cocaine, drug double, maximum 40
See, he
years.
has some revocations that they're talking about
I mean,
now.
I've given you so many warnings, and
They about
we
to
placed you in the recovery court program despite some of this high-risk behavior. You had multiple violations. We sent you to treatment, and you left treatment and then absconded supervision and had to get.
Okay. When he talks about treatment, certain at times, okay, before a person is sentenced or as a part of a person's sentence, how it works here, where I'm at in Arkansas, is basically a person could be sentenced to go to the Department of Correction, or they could be sentenced to go to the Department of Community Correction. And as a part of those Department of Community Correction, they have facilities like a inpatient rehab. You know, we call them various different community correction facilities, but they're basically like rehabs. There's, you know, well, there's one basically. You could be confined to that rehab if you have certain target offenses a person can go to, what we call CCC. Now, there's a difference between CCC and the Department of Correction. The Department of Correction has those big ranges, everything more than a year and up to life. CCC, the Community Correction Facility, only goes for punishments anything more than a year or anything up to 3 years. That's how that range is, up to 3 years. If a person needs to be sentenced to something longer, then they have to go to the Department of Correction. They won't be eligible. All right. Now he's talking about that this guy, this defendant, was allowed to go to rehab, and he did not complete the program. All right. Usually that's a part of your sentence. You must complete this program. If you fail to do so, then you could be revoked, and you could be forced to serve the original punishment in the Department of Correction. So he left, and then he left and did not go back to probation. So he left and he absconded. That's what that word abscond means. It means to leave supervision.
Arrested. That's not even taking into account that it's alleged that you've committed more than one felony while all that was going on, or while all this case has been going on. Even laying that aside, you've been just out of control, and we have tried to give you every treatment tool in our toolbox. You know, so now I got to reach for the other tools.
Okay. When he talks about the different tools, he's going by the old anecdote of using a carrot or a stick. All the other tools, the opportunities to not go to prison, have failed. So the only tool he has left is prison as a punishment.
You know, what your attorney's saying is a great pitch at the initial sentencing, and I bought it, and I put you in recovery court. And you and I have had several conversations, you and Mr. Fagan, you and Nicole. And I don't know why it just isn't sinking in. And it's not just that you're using drugs. I mean, we've got deliveries, we've got possessions with intent, we've got fleeing from police, we got fleeing from the police in a car, hitting another car. They're high-risk behaviors. It places people in danger. Not just you, it places other people in danger as well. So taking all those things into account, in file 6457, I'm going to, that's an advisory guideline range of 0 to 11 months. I'm going to revoke your probation and sentence you to, let's see, you have another 85 days credit, I think, because we've been adjourning this. So I'm going to order that you serve 284 days jail, give you credit for 284 days previously served. Any fines and costs that were previously assessed remain due and owing in the amount of any unpaid balance. That's 6457.
Okay. Keep in mind that he's naming out which cases he's talking about. So there's revocations. That revocation applies to each of those other cases that he has out there. So depending on how their prosecutor or district attorney This is a good point to actually talk about those two terms. Depending on what your locale is, they may call the person charged with bringing cases to court on behalf of the state either a district attorney or a prosecuting attorney. It means the exact same thing. The duties are the same. They represent the state in these actions to bring charges against defendants, bringing them into court so that trials could be had and a decision could be made whether a person is going to be punished or not. Okay, so let's hear what he has to say about the other cases. So you heard up to 11 months, he gave them 280 some odd days of jail time, not prison. Notice that the judge is very clear on when he's talking about jail and prison. So let's hear.
In file 6765, that's the fleeing and eluding. Third degree habitual second. The advice.
All right, you saw somebody else is saying they literally can't keep. So this is the person sort of putting a funny note in there. But these cases do happen like this in criminal court. I would suggest, because court is open, it's an open forum. You can come and just sit down in court and listen to what goes on. Keep in mind you have to determine which branch or which level of court you're going to go sit in, because you have traffic court, and that's usually called, or in my jurisdiction, traffic court is district court. Now they do more than just traffic offenses, but these are all, when you're talking about, it's mostly misdemeanors, things of that nature that a person will not go to prison for. They can go to county jail and be sentenced to a certain amount of time in jail, but there's a difference between district court and circuit court. Circuit court, where I am, deals with all the felonies. Okay, they deal with the things where people can potentially go to prison for the rest of their lives. Okay, or as you would say, probably the duration of their life. All right. They also deal with fines that can be up to, up to, I think the highest fine we do is $20,000, and that's for a class Y felony. All right. Um, from there, you have appeals levels. You have the Court of Appeals, and then you have the Supreme Court of Arkansas. Now, every state has a different way that they may determine their different hierarchy of levels of court, but it's going to be something close to that. Your lowest level, local courts will be called municipal or district court. You have a trial level of court that is the court of first review usually, and they call it first review because they keep a recording. They keep a verbatim recording of proceedings. All right, but this is considered the circuit court. So he can deal with felonies. He can deal with misdemeanors here. Let's see what he's going to do next on the second case. And he said he was a habitual.
Advisory guideline range is 10 to 28 months. I'm going to revoke your probation and commit you to the Michigan Department of Corrections for a term of not less than 28 months, nor more
28
than
months.
7.5 years. Exercising my discretion under the habitual offender statute to increase the statutory maximum to 7.5.
So you heard him. He sentenced him to 28 months, but he used the habitual offender part, and how that works. We could talk about that for a second. Or actually, let's go to our Michigan law. We'll come over here and we'll follow up. How is sentencing for habitual offenders term of imprisonment affected in Michigan? All right, you see it brought back quite a bit of information here. And once again, while I like this one, it gives you the citations over here of different stuff that it found. All right. It also can give you pictures if there are pictures involved with this. I don't have any pictures that are directly involved with what I asked for, so they'll be very random. All right, let's read what it has to say about the Michigan habitual offender sentencing enhancements. All right, it says in Michigan, the sentence for habitual offenders is governed by specific statutes that enhance penalties for those with prior felony convictions. Here are the key points: habitual offender statutes. All right, this is where you actually find it in the Michigan Criminal Code. Okay, all right, 769.10, 769.11, and 769.12, or 0.1121011, however you want to do those ordinals. All right, let's talk about this first one here. And I'll move my mouse to it so you can see. We'll start here. All right, it says this one applies to individuals with one prior felony conviction. The court may sentence the person to be imprisoned to a term of imprisonment for a maximum term of not exceeding 150% of the statutory maximum of a current felony. All right, let's bring up a calculator here. All right, so we heard him say 28 months was the highest. So 28 months is 2 years and 4 months. So we will make that 2.25. And you can say times 150%. So I don't know how he's getting to that 7 years, and that's interesting because he say anything from the term of it can only be up to 150%. Oh, don't listen to me. Don't listen to me. All right, why that's important is because obviously he had more than one prior felony because it's only 150%, and that makes 3.375 years there for that. The next one is an increase. We have 2 prior felonies. It increases it to up to 200%, which is times 2, wherever time they could have did. So that makes 4.5 years. This other one, 3 or more prior felonies. The court may sentence the person to imprisonment for life. They have a three strikes law. That's what this means. 3 strikes law. All right, for life or for a lesser term if the subsequent felony is punishable by a maximum term of 5 years or more. If the subsequent felony is punishable by a maximum term of less than 5 years, the court may sentence the person to imprisonment for a maximum term of not more than 15 years. Okay, they have a little adage in here. So for certain felonies, you can get up to life. If this is the 3rd time, you're in trouble. For ones that only have a maximum term of 5 years, all right, but if it's less than 5 years, what the punishment will be for this imprisonment term, you can go up to 15 years. All right, so let's jump back over and let's listen to what the judge is going to say here.
By my count, as of today, 225 days credit.
We'll go back just a little bit
By my
here.
count, maximum to 7.5. You have credit for, by my count, as of today, 225 days credit. Any fines and costs that were previously assessed remain due and owing in the amount of any unpaid balance. And that is a sentence within the advisory guidelines.
All right, let's talk about this for a second. Sentences within the guidelines. Okay, why it's important for him to make that statement or for it to be on the record is because if the sentence is within the guidelines, that has an effect for appeal purposes. Anytime a judge goes beyond the guidelines, that usually is a That's an appealable issue. Why would the judge go beyond the guidelines on this? And then the judge will have to explain on the record why they are deviating. And that's what it's called when you go outside the guidelines, a deviation. Okay. Let's look up this really quickly while we're talking about this. This actually is kind of on point. Appeals of sentences based on deviation from guidelines. Okay, let's see what it pulls back and what it says. All right, we're still in Michigan. All right, and that's the key thing we're going to do when we talk about stuff. We'll talk about stuff based on where that person is, because those laws will always be different than what the laws are somewhere else. A lot of places share many of the same laws, but may be different. All right, appealing sentences deviating from guidelines in Michigan. Appeals of sentences based on deviation from guidelines in Michigan. In Michigan, appealing a sentence based on a deviation from the sentencing guidelines involves several key points. Number one, sentencing guidelines. The Michigan sentencing guidelines provide a framework for determining the appropriate sentences based on the severity of the offense and the offender's criminal history. In many places, they have like these grids, and it's just like a chart. A person is considered a seriousness offender of a level 1 through 9. And based on that 1 through 9, you just follow the chart out, how many years a person should receive. Understand these guidelines are advisory and not mandatory. You see that where it says that here? So they are only a term of, they're only put there to advise the judges on what they could do, and not to be a shackle, because judges, they see cases on a case-by-case basis. While there may be old law here that may be applied, a person can come in with an argument that is so novel and on point that a judge will deviate from what the norm is. All right, deviation from guidelines. A deviation occurs when a judge imposes a sentence outside the recommended range. This can be a departure based on specific factors, or a variance based on statutory factors. See, this term is different than what we use here, but it still means the same. Sometimes there's a range put in the statute of what you can go from. Standard of review. Appellate courts review sentences for reasonableness. Look, this is a key term that you see come up all the time in criminal law and in civil law. Was it reasonable what happened? And you may wonder, why do they use this term reasonable so much? Because you have to find a standard somewhere that you're going to apply for everyone. And usually something being reasonable is probably the best place to start, where there could be a standard, a baseline standard for everyone. Was it reasonable? And you was something reasonable based on, your knowledge of the area, how people act there, and what people know to be the right or wrong thing. What's reasonable for one community may not be reasonable for another. All right. Reasonable. This standard is deferential, meaning the appellate courts will not substitute its judgment for the trial courts unless the sentence is unreasonable. So that means they give discretion to the trial courts to make those decisions. The reason is because the trial judge is there. He heard everything that was said. He was able to look at those witnesses and tell. Sometimes you can just look at a person and tell, okay, this might not be the full truth, or this may be a lie, or I just don't think I'm going to give any weight to what this person said. And that's all because of a person's demeanor. There's also times when that judge is the one who actually saw what evidence was trying to be produced based on the facts. And that evidence might not be the correct evidence that shows a nexus to the argument being put forth. All right, grounds on appeal, you got procedural error and you have substantive unreasonableness. The sentence is too harsh or too lenient based on the circumstances. Most times the sentence is too harsh, that's when the defense will be filing. If it's too lenient, that's when the state will be filing for appeal. All right, procedural errors are mistakes in calculating the guideline range or applying the guidelines. These errors are easy to correct. That's basically somebody looked at the chart wrong. If you had two numbers that were right beside each other and someone picked the wrong box simply by they didn't move their finger over as they were tracing where they should go on the chart, up and down, they may have put their finger in the wrong place and just call out the wrong number. It happens. All right, they have the recent cases, they have the appeal process and potential outcomes. All right, we don't need to hear about those right now. Let's jump back over here. Let's finish up with this video. It's at 7:55. We got 4 minutes left.
In file 6764, on account of, well, I'm going to revoke your probation and any fines and costs and any remain due and owing in the amount of any unpaid balance. For the delivery of methamphetamine charge,
See, these charges get worse and worse.
guidelines are 51 to 85 months. The drug double would.
All right, 51 months is, what's that, 4 years and 3 months to all the way to 85 months. So we know that 81 months would be 8 times 9. So this is almost 7 years. 7 years and no, this is 8 years. This is 8 years and some change. 8 years and some change. How much is 85 months? 48 and 48 would make 96 would be 8 years. So this is 7 years and some months.
Me the discretion to double that to 102 to 170 months. I'm not.
Look how that range changes. It went from 51 to 102. So he's doubling it based on him having 2 or more. So I think he's going by 200% range here.
I'm going to exercise my discretion to increase the guidelines, but I am going to exercise my discretion to increase the maximum penalty under the statute. So for that case, Mr. Sayers, I'm going to commit you to the Michigan Department of Corrections for not less than 85 months, nor more than 40 years, with credit for 225 days previously served. That's a top end of the guidelines without the drug doubling. I believe that is proportionate, given his absconding supervision and leaving treatment. And again, I'm not exercising my discretion to double those guidelines. I'm leaving them undoubled, but at the top end. I am exercising my discretion to increase the statutory maximum from 20 to 40 years, however. On the count possession with intent to deliver methamphetamine with the drug double, the advisory guidelines are 72 to 120 months. I would have it within my discretion to double that to 142 to 240. I'm not going to do that.
So you hear a bunch going on here. You hear about him saying he's going to double some things and not double others. That's why before a person is accepted into the Department of Correction, they have this signed form where they actually laid out what is going to be the actual sentence. You know what I'm saying? And it will say basically your sentence is going to be this and this. These are also public documents. They can usually be found on some version of the court system's electronic format in most states. All right. Also, it can be found at the Department of Correction because they have to receive this document and they keep a record of how much time a person has remaining, on their sentence.
However, because Mr. Sayers walked off of treatment and absconded treatment court
Well,
supervision
he
while
keeps
all
going
of
back
this
to that
is
walking
going
off of
on.
treatment. That basically
I'm
means
going
he
to sentence
left.
him to the upper end of the undoubled guidelines
He
and
left
commit you to the
prison.
Michigan Department of Corrections for not less than 10 years or more than 40 years. Credit for
It was 10 to 40
225
again.
days previously
It's 2
served,
times he has it 10 to
increasing
40.
the statutory maximum by
The last thing he's going to have to determine is whether he's going to have to serve these times consecutive, meaning that you have to complete one term before you can start serving the new term, or all together as a concurrent set. If he's going to make him serve them as a concurrent set, then that means that he will be able to serve one term of 10 to 40 years. And it sounds like when you submit this sentencing order to the Department of Correction in Michigan, so here in Arkansas we give exact terms. We'll take the range out, and that's where the judge decides what the exact term you're going to serve. And then, depending on how your behavior is in the Department of Correction, they may parole you sooner than what that max term is, but you'll still be under the purview of the Department of Correction until you complete that term. So you would be paroled and placed on some sort of supervision, supervised probation, until your term is complete. Now, we also have suspended sentences where you don't have you won't have to go see a probation officer. But if you get any new charges or you get into some type of trouble, you could be revoked from that suspended sentence and be forced to go serve the underlying charges original time.
the drug double statute. And on the possession with intent to deliver cocaine,
He has more charges.
drug double, 40-year maximum, advisory guidelines 10 to 23 months. I'm going to not double the guidelines within my discretion, but sentence you again at the upper end of those guidelines at 23 months to 40 years. Credit for 225 days previously served.
1 year,
Exercising my
11
discretion
months,
to
all the way
increase
up
the
to 40
statutory
years. That's a
maximum, however,
long
not
range.
increase the guidelines. And again, top end of the guidelines is certainly proportionate in this case. All right, and Mr. Sayers, you have the right to file, you are able to file an application for leave to appeal if you wish on any of these cases. If you want a lawyer, I give you one, but you have to ask me within 42 days. So we're going to hand you some paperwork explaining that process. One copy is for you to sign. If you want to take an appeal, the other one, we're going to ask you to initial one in all 3 files so that we have a copy of it. And then we'll just have to writ them out or do it by video to deal with the pending cases, but I'll not have you in our jail any longer, sir. Good luck.
So when a person has had issues at the jail where they're being held, a lot of times that might force you to head into the Department of Correction or force your client, if you're an attorney, or force your family member, if you have a family member going through this process, to end up in the Department of Correction much sooner than they were looking for if they're having issues keeping that person at a jail, okay, at a county jail or a city jail. All right. So this was just a once again, a judge. What happens when a judge loses their patience, and or what happens when a person's opportunities have run out. All right. Thank you once again for joining me, Professor Ross. This is Advocacy Alchemy with Professor Ross, and you all, if you haven't had a chance to subscribe, do so. If you have any particular types of videos you would like to see, or any information you would like me to talk about and teach on, get back in contact with me and I will produce a video to speak about that. With that, everyone have a good evening.